My name is Patsy Ramsey, and I'm 5.5.
And that's backwards.
How do you prove you're not guilty?
Hello and welcome to True Crime Rocket Science, the most authentic voice in true crime. This is episode 17 in the Carnes Order series, dealing with evidence in support of the intruder theory. We're at around about page 66 in the 93-page order, and we need to cover about 12 pages in order to get to the next episode, the beginning of the next episode, which is the analysis of the two theories. So what is happening now is the judge is sort of considering both theories, the intruder theory and the theory that Patsy Ramsey may have been involved, on their respective merits. I think we need to jump in as soon as possible in order to get through that. But before we do, if you haven't subscribed yet to the channel, please do. There's a light blue icon on the bottom right of your screen. You can click on that to subscribe. Hit the notification bell for notifications. Like, share, leave a comment, and let's get started. Right, so evidence in support of the intruder theory. Now, we dealt with the issue that truth is an absolute defense against libel. And so one of the things that is being tested here is what is more likely to have happened, that the Ramseys were involved or that an intruder was involved. And so the judge is now considering the intruder theory, right? And this is quoting from the Carnes Order. Defendants assert that the evidence establishes that Mrs. Ramsey did not murder her daughter, JonBenet. As a way of reinforcing this, it refers to the defendants noting that after a half-decade investigation into the murder of JonBenet Ramsey and a year-long grand jury investigation, no plausible evidence proves Patsy Ramsey had anything to do with the murder of her child. Every prosecutor to examine this case agreed that no charge or crime should have been brought against the defendants. Now, we can immediately take issue with what the judge has said there. Referring to the year-long grand jury investigation, it was actually even longer than that. It was closer to a year and a half. But there was plausible evidence proving that Patsy Ramsey was, the grand jury voted to indict her for something. So the grand jury didn't let Patsy Ramsey off the hook in the way that Judge Carnes is assuming that she was, certainly based on what defendants were suggesting here. Have you ever wondered whether the Ramseys may have known the outcome before everybody else did? And what I mean by that is, if you consider the scenario, so we know in retrospect that there was a grand jury investigation, but was it ever going to go anywhere? Was it ever meant to go anywhere? Right? Now, if you think about it in this way, that the Ramsey attorney was once a colleague of Alex Hunter, the district attorney, isn't it possible that they played kind of a long game where they sort of knew outcomes ahead of time? And if you think of certain legal idiosyncrasies to this case, I'm not going to spell them all out, but one of them is if you can't try a case because of the ages of people involved, or you have a scenario where that is sort of pushed to the side, then the only matter you've really got left is something regarding, let's call it, the statute of limitation. So if you're playing a long game, then once the statute of limitation runs out, then you effectively win the case for your clients, right? And so I don't want to go into more detail than that, but I just wonder whether the Ramseys didn't have an idea of what the result was of the grand jury investigation ahead of time. And the only reason I'm saying that is they hired very high-powered attorneys, and the whole of Boulder was sort of this chummy legal culture. So why on earth wouldn't the lawyers be talking to the lawyers, and then also talking to the Ramseys? And perhaps the Ramseys were told, look, just pretend like you don't know the outcome, pretend that you are relieved, blah, 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 blah. Haven't you ever thought about that? I certainly have. And in a way, I think you could see it from a long distance away. You could see that Alex Hunter was resistant to bring about a grand jury. We could see before he brought about the grand jury, he only really brought it about when some of his investigators resigned in disgust. So, number one, it took a really long time to get to the point to bring one together. And then number two, after it was all done, well, then there was this impression that there wasn't enough evidence. And that was also something where the public were led to believe something that wasn't true. So one wonders, if you had to ask Alex Hunter, would you have wanted to have a trial? And even if there was a huge amount of evidence, would you have wanted to have a trial? And it's difficult to imagine that he did, just based on his track record. So one wonders whether, would it really be strange to imagine the outcome as it was before it was actually asserted, right? Before it became public knowledge, even though, as I say, that public knowledge was I don't want to say misrepresentation, but the public were misled. The actual facts of the matter turned out to be different to what they were. And I just want you to bear that in mind when you look at the text of the Carnes Order, where she says, quote, "Every prosecutor to examine this case agreed that no charge or crime should have been brought against the defendants," end quote. And of course that stands in contrast to what some of the police were saying, what some of the people in the media were saying, what some of the people in the public were saying. Anyway, going back to the Carnes Order, defendants contend that evidence gathered in the investigation of JonBenét's death instead shows that she was abducted, sexually assaulted, tortured, and murdered by an intruder. Now, I want to again take issue just with that paragraph. First of all, she was never abducted. I mean, she never left her home, right? So that first word there is not actually true. She was never abducted. Number two, there is evidence that there was sexual interference. I don't like to call it sexual assault. People who know me know the reasons why. Just because the sexual contact was of a relatively, how can I put it? I don't even use the word benign, but it was a relatively, put it this way, the Ramseys initially discounted sexual assault themselves. In fact, John Ramsey at the very first press conference said that he felt insulted by the fact that people thought that this was going on. And then as time went by, it went from there was no sexual aspect to the case and certainly no pattern of sexual contact to, well, there was a paedophile involved and it was almost like JonBenet had been raped or something. Meanwhile, there was a certain amount of inflammation that was, I think, worse than vaginitis, but certainly the Ramseys in the beginning were conflating it with that. I'm just saying, even on this measure, I think it is exaggerated to say that she was sexually assaulted. I think when you talk about sexual assault, you've got to imagine that it is without consent, that it is something that is violent, something that is, in that sense. And I'm not sure that I believe that it was. I do believe what followed it was violent and reactionary. Where it says that she was tortured, I don't know if that's true either. I don't know if JonBenet was tortured. I think she was hands were bound, but didn't she volunteer to have her hands bound? It's a question. Did she allow someone that she knew to put the noose around her neck? And some people might gulp at those words, but you could have a scenario where there's a game that is being played or something like that, and children volunteer all the time to be put in certain situations. So I don't know whether she was tortured. I think you can certainly make the case, if you're trying to make the intruder theory, that all of these are true, but I would argue with each each individual one of them. She wasn't abducted. The sexual assault was less grave than is being presented. In other words, I don't think it's the kind of sexual assault you would associate with an adult assaulting a child in a way, like she wasn't violated in a typical way that we associate with those terms. So in terms of torture, I don't think she was garroted, even though, that the implement used to murder her is called a garrote. I don't think it actually was a garrote, or that it was intended to be a garrote. And then the fourth point there, that she was murdered by an intruder. To be honest, I don't think JonBenet was murdered. I think JonBenet was killed by accident, and that's different. So on all four of these points that the defendants contend on, I think that they are either exaggerations or they're just not accurate, right? You must also, if you disagree with me, you might say, no, she was abducted, she was sexually assaulted, she was tortured, she was murdered. Well, why then would you wrap her up in a blanket afterwards? Then in the next paragraph, she introduces Lou Smit, and this is quoting from the Carnes Order. As Andrew Louis Smit, a respected homicide detective hired by the Boulder Police Department to investigate this crime, has noted, there are only two possible solutions to this crime. That is, either someone in the Ramsey household committed the crime or an intruder did it. And that's from the Smit deposition. It's interesting how he says Ramsey household, because can't the Ramsey household include the housekeeper? Can't the Ramsey household include all family members? And bear in mind that there is quite an extended family. So, I think you need to be more specific than he has. The other thing that I don't think is accurate there is Lou Smit was hired by the district attorney, and it was the district attorney who placed Lou Smit in the Boulder Police Department. And you would imagine if they didn't get along, that the district attorney would say, you know what, this isn't good for the investigation. The fact that there's arguing between this outside outsourced investigator and the Boulder Police Department, it's not good. It's not a good look, and it's not good anyway. Let's get somebody else then. Let's get someone that where they can see eye to eye. And so you must get the sense that did Alex Hunter anticipate this, and perhaps was this by design, or was this just accidental? But you do wonder, if you wanted the investigation to succeed and you found that Lou Smit was at cross purposes to the Boulder Police Department, well, wouldn't you then get somebody else? The other thing is, my impression, I could be wrong, was that Lou Smit was hired to, he was sort of hired to, and sort of he was informed that I want you to look at, we believe the Ramseys are innocent, I want you to look at other possibilities. And so you kind of get this investigator coming in, and he's been given almost, like from very respected people, very powerful people, is sort of been given the information that, it's not the Ramseys. And so why wouldn't he accept that? Smit was a respectable person himself. He was a family man. He was a Christian. And so why wouldn't he respect that sort of legal hierarchy to say, it does make sense. And so I'm going to fight the good fight. And it is wrong to implicate this innocent family. So couldn't that also be part of the scenario as well? It's a question. Anyway, it goes on to say, defendants contend that the weight of the undisputed evidence in the case is consistent with an inference that an intruder killed their child. The first questions then are whether an intruder could have entered the home, and if so, is there evidence that an intruder in fact entered the home on the date of the murder? This is quite a simple but profound issue, legal issue. It is, you're saying, okay, so the Ramseys didn't commit the crime, so someone needed to come from outside. And before you even deal with the identity of this person, the motive of this person, the handwriting of this person, anything, let's follow the route that this stranger intruder took into the house, right? And so that is the first and the classic route that you take when you try and make the case for the intruder theory is, well, what route did the intruder take, right? And so she says, is there evidence that an intruder in fact entered the home on the date of the murder? Defendants respond that the undisputed evidence supplies an answer of yes to both questions. So effectively the Ramseys are saying, did an intruder enter the home? Undisputed answer, yes. And then, is there evidence that an intruder entered the home on the date of the murder? Undisputed answer, yes. Oh, okay. Now, what's quite important here is that they're saying on the date of the murder, well, the date on John Bonet's gravestone is the 25th of December, which I believe is incorrect. I think John Bonet died on the day after Christmas or the morning after Christmas. So, you know, they're saying, well, there's a undisputed answer, yes, to an intruder breaking into the house on Christmas Day. No, there isn't. In any event, continuing with the Carnes Order, it goes on to say at the bottom of page 67, first, defendants have indicated that the house was not secure during the night of December 25th, 1997, and that they had not turned the security alarm on. In addition, at least 7 windows and 1 door were found open on the morning of December 26, 1997. A number of windows were accessible from the ground level, including a window well with removable grate over 3 windows that opened into a playroom area of the basement. Now, I do think it's quite interesting that the intruder breaks into a playroom used by children. That is where he breaks into. It's quite interesting that's where he goes into. And also he breaks a window in where he needs to go down into the basement, when he could have just broken any other window. You could have broken a window by the kitchen and just opened the kitchen door and gone in that way and come out the same way. But I do think the whole thing where they say, you know, that there were windows open, doors found open, and also they didn't turn their security alarm on, I think that plays into the same narrative of John breaking into his own home months earlier, and then they, they never fixed that. So it's basically saying, it's almost in simple language saying, by the way, we left the front door open on Christmas night and we just rolled out the red carpet, and guess what? Lo and behold, an intruder happened by and walked on the red carpet, entered the front door, and everything was sort of available and accessible, and then this intruder did something. It was a sort of opportunistic thing, and that this makes complete sense on Christmas when everyone is at home. Someone would go and do something like that, and it would be a stranger intruder, not a family member, not a friend of the family even. Now, I don't want to talk about the habits of the Ramseys in terms of security. The housekeeper would probably know about that better than we would. And also, we know what the Ramseys were like dealing with their own security after this event, right? But in any event, it goes on to say, there is likewise undisputed evidence of a disturbance in this window well area, specifically the leaves and white styrofoam packing peanuts that had pooled in the window well and appeared to have been cleared from or brushed to either side of the center window sill in the well. Now, I've got to say, I find that absolutely ridiculous. If I don't know how you can say it's undisputed evidence, because you just need to look at the actual crime scene photos to see that there are leaves and dirt that are right in front of the window. But since we're already at the 20-minute mark, I'm not going to deal with this issue in this episode right here. I have spoken a little bit about it on Patreon, so I'll make a separate video dealing with the crime scene photos of this area of disturbance, quote-unquote disturbance, in the window well area. And it's just going to show you how ridiculous the whole argument is. It's almost like seeing is believing or seeing isn't believing kind of thing. It goes on to say, in addition, the center window had a broken pane and was found on the morning of December 26 with a suitcase and a glass shard from the window pane underneath it. Green foliage was also found tucked under the movable grate of the window over the window well, indicating that the grate had been opened and closed. The term open was not defined. It is therefore not clear if the entrances were ajar or unlocked. Quite interesting. So something was open. Or what does open mean? Oh, we don't know if it was locked or if it was literally open. Oh, well, that's convenient, isn't it? The statement that there were at least 7 windows and 1 door open, I don't know whether that really comes from, because the police certainly didn't mention that. Linda Arndt doesn't mention that in her report. Reichenbach doesn't say anything about all these windows that were open. And I do think it's a situation where the police arrived and looked around the house, and then later on, as they were looking around the house, things were opened, and then suddenly you could say, oh, well, look, while there's an open window, the intruder got through there. There's an open door, the intruder got through there. But certainly not right in the beginning. So it's quite a big statement to make, but it just seems very weird. There seems to be one window that was an entry point, not 7, one window, and even that window was said to be closed. So it's a strange statement. If anything, the doors that mattered were the door to the wine cellar, which was not only closed but latched, and also the door going into the train room that had a stool in front of it, also closed. And are you telling me the intruder closed the broken window behind him after he left? I think one of the possibilities with the door being open is from Fernie's testimony, John Fernie. And John Fernie apparently said something about arriving shortly after 6 o'clock. I think his wife arrived separately about 10 minutes later than that. And he told his wife apparently that the door to the butler area was open, and I don't think he was correct in that, because he didn't actually walk around that entrance. He was, if you look at a map of the Ramsey home, and I'll do an episode on that as well, a separate episode, so I'm going to be doing 2, one dealing with John Fernie's evidence and one dealing with the styrofoam peanuts that were apparently to one side. And but in any event, the patio door that John Fernie walked by, and where he said he could see the ransom note through that is on the opposite side of the house to the butler entrance. So it just doesn't make any sense that John Fernie would do a loop of the house on his way to entering the house. In any event, you get the impression that what was said to Smit either misunderstood or misconstrued, and this led to this kind of difference of opinion. But there was another occasion where John Fernie said the following. He said, I drove my car up the alley, parked in the back of the house, went around to the patio door that's on the kitchen side, which is a glass door leading into the kitchen and back of the house. The door was locked. Now, there is obviously there are some photos of the exterior of the house, and some of them include, I believe, the butler entrance. But what it looks to me as though they're doing there is that the door is open so that they can examine the locks, and the one door has what looks like either whittling or some kind of damage to the wood on the inside, and that looks like what they are looking at there. I've seen other arguments online that sort of make the case quite well, that, you know, Lou Smit only arrived on the scene 3 months later. So how the heck can you make the case about the intruder theory about evidence based on an investigator arriving at the scene months later. You really need to be referring to police reports and to some extent crime scene photos, but crime scene photos that matter of certain potential points of entry into the Ramsey home. And the one thing that I've never understood is, if you're going to make the case that the intruder entered through the grate, then why does it look like there are no footprints in the snow leading up to that grate? Something I've also thought about quite often is, was the window in the basement broken from the outside in or from the inside out? And, if they'd taken that window out of its frame, I don't mean the glass, I just mean the whole structure, and but in any event examined it, I think you could have determined what was true. In other words, was the glass of the basement window, was it broken from the inside out, which would discount an intruder scenario, or from the outside in? Just because I don't think an intruder did break it, but if it was broken, how was it broken? Now, of course, it's possible that someone could have opened the window and tried to break it nevertheless so it would seem from the outside in. But it would just be interesting to verify that. One of the ways you can, I guess, establish that is there to some extent a bending of the glass outwards? And I've tried to look at the video of the basement window and photos of it. It's very difficult to say either way, but it would be interesting to know. I don't think it's a question that has been asked, and I think it's a question that needed to be asked and should have been asked. I've also heard people complaining, saying, well, what does it matter about other windows being opened or doors if the intruder came through this particular entrance? Isn't this particular entrance the one that we're talking about? But I think the inference is made here that the intruder either came through the butler entry and then exited through the basement, or came through the basement and exited. Who knows what is actually really being contended there. The Carnes Order goes on to refer to a pillow, sham, duvet, and Dr. Seuss book inside a suitcase. These items belong to the defendants, but they have indicated that the items were not normally stored in the suitcase. A lab report indicated that fibers from the sham and duvet were found on the shirt that John Bonet was wearing when she was found in the wine cellar. On page 69, further, the Boulder police conducted experiments that showed a person could enter the basement playroom through the center window. Moreover, leaves and debris consistent with the leaves and debris found in the window well were found on the floor under the broken window, suggesting that someone had actually entered the basement through the window. Likewise, a leaf and white styrofoam packing peanuts, consistent with the leaves and packing peanuts found pulled in the window well, were found in the wine cellar room of the basement where John Bonet's body was discovered. This evidence is consistent with an inference that whoever entered through this window ultimately walked to the wine cellar room at some point, or from the wine cellar room at some point, I would imagine. Certain undisputed evidence of how defendant's house was found on the morning of December 26 is also consistent with the intruder theory of the crime. For example, the lights were on in the basement when first searched at 6:15. I'm just going to stop there for a moment and go back to this notion about the debris. I'm going to deal with it in a separate episode, but it's quite strange that, the first police officers on the scene, according to Steve Thomas, examined the steel grate covering the window well. They found undisturbed cobwebs still attached from the grate to the bricks. So that's the first point. Also, the foliage around the grate also appeared undisturbed. And I've got to say, just looking down at the dirt below the grate and in front of the broken window, that doesn't look like someone went down on their hands and knees or stood there and then went in. It just doesn't look that way at all. You even have further details from police officers like Detective Mike Everett and Sergeant Tom Wickman, who said they saw at least 3 strands from a spider web and cobwebs in the corner of the window frame. There's a rectangular piece of glass resting near the middle of the exterior windowsill. I think that's also on some of the crime scene video footage. And this is quite important, and it's a quote from Foreign Faction. There was a collection of pine needles and leaves on the top of the grate. And so to enter that window without disturbing all of these things would have been difficult, basically not possible. I think you also need to bear in mind there was pine needles and leaves at the bottom of the grate, and these weren't disturbed either. It does feel a lot, and again, this is a sign that the prosecution, the plaintiff in this particular case, was perhaps derelict in his duty. He doesn't mention that, Lou Smit had gotten a lot of credit for his work in the Heather Dawn Church case, and basically what he was doing here was the same exact thing he did in that case, which is basically intuit an intruder and then find some kind of I won't say random, but an isolated piece of evidence, and suddenly case closed, case solved. And I think he was trying to apply that psychology which served him so well in that case, in this case. And to some extent he got credit for that, including by Judge Carnes. But in another way you can see that he was reaching, wasn't he? I think it's also important just to stress that what Lou Smit apparently said here about that there was plant and leaf debris on the basement floor, that's not true. There might have been plant and leaf debris on the basement floor when he was there and when he did his demonstration, but there certainly wasn't plant and leaf debris on the day of the incident. Nobody spoke about it. Fleet White didn't mention anything. Nobody mentioned anything about that, and you would have imagined that they would have. And they didn't mention it because it wasn't there. It's not just a matter that no one mentioned it. It's also there's not a fragment of leaf or pine needles or dirt or debris in crime scene photos of the basement where you can see the floor, and also from crime scene video, you just don't see it. Then going on to the bottom of page 69 and top of page 70, it refers to, contrary to media reports that had discredited an intruder theory based on the lack of, quote, footprints in the snow, unquote, there was no snow covering the sidewalks and walkways to the defendant's home. Hence, a person walking on these paths would have left no footprints. I've already dealt with that, but all I want to say is, if just this small aspect had been ascertained, you wouldn't need to deal with any of the rest. If you could just have shown that there were no footprints in the snow, there was snow and there was frost and there was no footprints in it, you wouldn't need to deal with any of the intruder theory whatsoever. Then what's quite interesting on page 70, it goes on to say, defendants further aver that the undisputed physical evidence is not consistent with an accidental killing followed by staging, but instead is more consistent with a theory that the intruder subdued JonBenet in her bedroom and then took her to the basement where she was sexually assaulted and subsequently murdered. First, now, what I think is completely missing from that whole story is where does the ransom note fit in? Where does the ransom note fit in with that whole deliberate scenario, perpetrated by some adult who had murderous intent? First, JonBenet's body was found bound with complicated and sophisticated bondage devices. So, first of all, they weren't complicated, they weren't sophisticated, certainly not for certain individuals, and they weren't bondage devices. I mean, she could easily have slipped her hands out of the knots if she wanted to. And she calls them neatly made rope slip knots and a garrote. I don't think it was a garrote. Designed to give control to the user. I think that to some extent is true. I think it was designed to give a semblance of that the person is being submissive or that the other person has control. I think that part is true. I think the other side of the story is when it appeared that JonBenet wasn't under control, there was like overkill. There was panic that was totally irrational, in a sense. There was panic, there's an overreaction, not just in the sense of the bludgeoning, but also the strangling. There was sort of an absolute overreaction. And if you think about the overreaction compared to the how can I put it, the amount of control and in terms of the slip knots on the wrist, think about the mismatch between the looseness of the knots and the overcompensation in the actions that followed. Now, if you think about an adult in this situation, it would be so easy to subdue JonBenet. She's a 6-year-old child. It is so easy for an adult to subdue a child. It is just a matter of, you can use hands, you can use arms, you don't need to use weapons. And yet there are 3 weapons that are used. There's a garrote, there's a stun gun, there's a baseball bat or something, or a torch or something, and then there are also all these ropes and things. Why would it be necessary to have all of this stuff? Going back to the Carnes Order, it says the parties agree that such devices necessary were made by someone with expertise in bondage. Oh, really? In a way, I agree with that, but I don't agree with the word bondage. Someone with experience in tying ropes and playing with string and sticks and things like that. While it is certainly possible that defendants possess such unusual and specialized skills, and I think that part should have been explored a little bit more. How could it be possible that they would have these skills? It says there is no evidence that establishes this fact, and that unfortunately is a failure from, I guess, the police department to make some of those links explicit. Then it goes on to say, obviously, if defendants lack the skills to fashion this bondage device, then it necessarily had to be an intruder who crafted the implement. That's quite straightforward, but again, it's a failure from the prosecution to make their case. I'm not really going to go much through page 71. It talks about the paintbrush and the cord and the garrote that were never, the things that were used to construct it were never found or sourced to the defendants. Again, I don't know how you can say that the paintbrush wasn't sourced to the defendant. The black duct tape never been sourced to the defendants. That's disputable. Animal hair alleged to be from a beaver was found on the duct tape. Nothing in the defendant's home matches the hair. Well, I think Patsy left at midday, shortly after JonBenet's body was found, wearing a fur coat, wearing the clothes she was wearing the night before. It goes on to say, the above evidence arguably suggests that whoever tied up JonBenet used some items brought from outside the home to do so. In addition, other fiber evidence supports an inference that some of these items from outside the home were at one time in the second floor area near JonBenet's bedroom. That is, fibers consistent with those of the cord used to make the slip knots and garrote were found on JonBenet's bed. The paintbrush whose middle piece was used to fashion the garrote was found in a paint tray in the boiler room in the basement. This evidence is inconsistent with plaintiff's proposed timeline of events. This is the top of page 72. That is, the plaintiff has hypothesized that Mrs. Ramsey, in a moment of anger, had hit JonBenet's head against something hard in the second floor bathroom, thereby rendering her child unconscious, and then spent the rest of the night staging an elaborate kidnapping and torture scenario in the basement. Discovery of cord fibers used to tie JonBenet's hands in the latter's bedroom arguably undermines plaintiff's sequence of events. Now, just in this particular thing, why I just dispute it is, if that did happen, if Patsy did do something to JonBenet, she could easily have just called an ambulance, and then, if she didn't want to take responsibility for what she did, she could have just said JonBenet fell. So why wouldn't she do that? Why would she want to not only cover up the crime, but also prevent John Bonet from getting medical attention? That just is very unlikely, given that Patsy herself got so much medical attention for her cancer and her situation. There's quite a lot more to go through, but I'm not going to go through it just because we've dealt with it in the John Bonet series. What I am going to do is I'm going to do 2 separate videos, not very long. One dealing with the debris evidence outside the basement window, and another one dealing with John Fernie's statement about seeing the ransom note through the glass of the kitchen door. And we're going to look at that. For those interested in the research that I did with my co-author on the John Bonet Ramsey case, I'll put a link to the CRAVEN SILENCE trilogy in the description, so you can check that out. I'll be back otherwise with episode 18 in the Carnes Order either tomorrow or the next day. Thank you for listening, and I'll see you guys next time.